Okay. Since the last time I went live, they changed the settings again, so it took me a little bit to figure out how to come on here. And I was also getting ready our raffle, um, putting all the tickets in there. So, hello everyone, Jax West from Stephen Avery Project. I gotta put glasses on now that I'm gonna be reading stuff. Justice with Jax and MAM Gossip. Sorry I wasn't able to go live yesterday when this came out. I am working on way too many things at one time right now. And just didn't have the time. I also haven't even read it yet. I started to read it yesterday and it was pissing me off as expected that it was going to piss me off. Um but just thought it would be better than to read it with y'all. I'm trying to find the link right now to pull it up. Where is it? There it is. So, sorry, okay, I wasn't even on everybody's comments. So what it is Kathleen Zellner filed a couple weeks ago with the Wisconsin Supreme Court. We did a live video on that. So if you wanted to go back and read through or to watch that, you can find that live video, or maybe in the next 5 minutes, Christopher, since I mentioned that, will post a link to it. And you can also go to Kathleen Zellner's website, KathleenTZellner.com, and she has the link there where you could go to read her filing if you wanted to read what she filed that the state is now responding to. People always freak out when these state responses come back and they get to be, the people will be all doom and gloom and like it's over for Stephen or whatever. This is just the state's response, and of course they're going to double down on everything they have said before. So, and it's expected for them to do so. So it's nothing to freak out about that way, but I'm probably going to freak out and just because they're idiots, and it's going to piss me off. So you'll probably see me at points then go off on a rant. And I do try to censor my language because I've got quite a vulgar mouth. And so I try to remember and replace any naughty word with the word Smurf. So play along. And if you so try and figure out what it is that I really meant to say when you hear the word Smurf. Let me get, now that I have it pulled up on my other screen, let me post the link in here for you all too if you want to go and read it for yourself. Something else I want to warn everybody of: the Supreme Court, I believe there is no time limit for their response. You know, that's another way to drag all this crap out. And even when the Supreme Court responds, if it is negative, again, expect it. Something I had said to Christopher yesterday in talking about all this is I don't have any faith in any court anywhere, not just Wisconsin. Or Manitowoc, or, wherever. But especially in Stephen's case, anything that's coming from Wisconsin, they're going to try and protect their own. So, and this is just the game that gets played in our legal system. It is not a strike against Kathleen Zellner when a state denies anything that she's asking for, because it's expected. She knows it. That's why Kathleen Zellner, and now by me already gearing up to rant, I'm starting to get warm. So I'm turning a fan on. So you might hear the fan on my desk right now. But that's why Kathleen says it typically takes her 15 years. I know I'm beating a dead horse here because I go, oh, my sexy girlfriend. Miley, I just got a membership to Costco. I haven't gone yet, so I will be getting a pumpkin pie. Sorry. Um, um, Kathleen says it typically takes her 15 years to overturn a wrongful conviction from when she gets the case. And she has only been on Stephen's case since 2016, January of 2016. So there's still a lot of time to go. It shouldn't be that way. Our system needs to be fixed. Stephen, Brendan, all these other wrongfully convicted people should not be sitting there all this time while the courts take as long as they want and play this volleyball thing. But that's the way it is. Leah, before I start reading into this is a question we always get all the time, is about when is there going to be another season? I'm sure there would be another season if something significant happens in the case. So if Stephen gets an evidentiary hearing, if he gets a new trial, if he gets released like he should be, then there's stuff to cover. This batting back and forth in court is not enough. And Rachel and Chad, my strong man, thank you for being here, guys. Chad, so Rachel and Chad were two people that came to the rally we had at Stevens Prison, and this guy pulls semi-tractors for fun. So I used him to load up the stuff in my car. So that's why she said strong man there. Okay. So this response is only 12 pages long, and a lot of it's just junk, table of contents, all that stuff. I won't be reading any of that. Hello, Debbie. And while I'm reading this on this screen, I won't be following along on your comments because I'll be looking at the screen and reading it. And I'll be pausing at times when I want to rant about something. So don't think I'm ignoring you. If you comment, it's because I'm concentrating. I'm reading this. And, I try to multitask, but squirrel, I get distracted and I forget where I'm at, which you'll see me over and over again in here too when I go on a rant, and then I'm going to forget where I was at. So like I said at the very beginning, I have not read this yet. I started to yesterday. Christopher had told me I was going to get pissed off when I do read it, and I started to read it. I started to get pissed, and then I'm like, all right, I'm just going to wait. Now because I don't want to read it multiple times and get pissed off multiple times. So I'll just save it and read it with y'all. And anybody asking any questions or whatever in the meantime, other people go ahead and answer their questions for them. And when I'm done reading it, if it was a question you wanted me to answer, resubmit it when I'm paying attention and I'm not ranting. So we're starting on page 3 of 12. Because of the table of contents or whatever before it. Introduction. This court should deny Avery's petition for review. As he has done throughout this proceeding, in his petition, Avery has egregiously misrepresented the record, as the Court of Appeals repeatedly noted. And it has a footnote on that. The footnote says, see, blah, 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 a whole bunch of numbers, whatever. Quote, we note that Avery's counsel misrepresented some key facts underlying this claim in the motion to the circuit court and briefing to this court, ... When there's the dots, that means they're leaving out text and only putting in what they wanted. So this isn't the whole context of what Kathleen had said. This is just the little nuggets that they dug out. That Avery misrepresented the facts is immaterial to deciding his Brady and ineffectiveness claims. We point them out because of the high-profile nature of this case, ... and the resulting need where misrepresentations are particularly egregious to note where Avery's argument wholly stray from the facts, unquote. Then back up to the introduction says, the law, the lower court's opinions, and even his own argument. And that has a footnote. And this footnote says, for example, the state never claimed that bullet FK or FL was used to shoot Halbach in the head. Really? The state's forensic anthropologist, who you can't believe a single word that woman says, found 2 gunshot wound holes in Halbach's skull bones. In Halbach's skull bones. Okay, whatever. The medical examiner found the same thing and opined that the cause of death was 2 gunshot wounds to the head. When asked on cross-examination how he could tell either shot was actually fired while Halbach was still alive, and he responded that he could not definitively make that determination, though he had been told by someone else that Halbach's blood was found on one of the bullet fragments, which could have occurred by passing through the brain. At no, it's got no italicized, at no point did any state's witness testify that the 2 bullets recovered from Avery's garage were actually the 2 bullets used in the fatal shots, as Avery claims. It is Avery, not the Court of Appeals, who, quote, grossly misinterpreted the state's forensic evidence, unquote. Rant time! Okay, so you're claiming the state is not saying that those 2 bullets went into Teresa Halbach? Then why are they evidence? And why are you claiming there's Halbach DNA on them? If you're now trying to say the state never said that. That makes absolutely no sense. They 100% claim that these 2 casings, bullets, I don't know what you call them. I should know. My husband is an NRA instructor with this concealed carry. Oh, sorry. Squirrel, got an email. So that makes no sense to me. And let me again point out, I am not a lawyer. I am not basically a lawyer who pretends to be a lawyer just so they can bash everything Kathleen Zellner does. But I'm pretty sure that the state said these 2 bullets that they found went into Teresa Halbach. All right, back up. The only question... Oh, wait, no. That footnote continued. Sorry, I thought it was done. Avery has also miscast his claims in his petition and changes his arguments or raises new ones that he forfeited below. For instance, he now attempts to set up the straw man argument that the Court of Appeals misapplied Strickland versus Washington when evaluating claims that he himself presented as newly discovered evidence and not is italicized, ineffective assistance in the lower courts. This misrepresentations of this sort in Avery's petition regarding both the law and the facts are too numerous to list. Are you smurfing kidding me right now? Too numerous to list. Which one what petition are they talking about there? Are they talking about one of Kathleen's petitions? Or are they talking about when Stephen didn't have legal representation and he had filed something that they keep trying to punish him for now? Like, you should have known XYZ, even though none of that stuff was known at that time, and you don't have any money or experts. But Kathleen Zellner making misrepresentations that both the law and the facts are too numerous to list is laughable. So are they going to compare Kathleen to when she has a deal with the state to give her the bones and the car, and then they accidentally call her to talk crap? Yeah, okay. Let's talk about whatever. Okay, so back to the text, not the footnote. The only question properly raised by this case would be whether the Court of Appeals erred when it found that Avery's motions failed to plead sufficient facts that were actually supported by some evidence to both overcome the procedural bar of Wisconsin Statute 974.06 and State versus Escalona Naranjo, and to require an evidentiary hearing. Wait, let me say this again. Properly raised would be whether the Court of Appeals erred when it found that. Okay, so the way I'm reading that paragraph is that he should get an evidentiary hearing? Or are they admitting themselves that should have gotten one? Oh, there's a douchebag trying to mouth off about me right now. Whatever. All right, back to this. Even a casual review of the record shows that the Court of Appeals correctly applied the law and appropriately held that the circuit court was not required to hold a hearing on any of Avery's issues because Avery's motions were all utterly devoid of factual support sufficient to lead to the conclusions Avery claimed. Avery's motions were insufficiently pled, and the circuit court had discretion to deny them without an evidentiary hearing. So at best, Avery asks this court to engage in error correction of non-existent errors. This court is not an error correcting court. And there is no compelling legal issue here that meets any of this court's criteria for review. There is nothing novel, unsettled, or any need for clarification about what a defendant must plead in his section 974.06 motion to be entitled to a hearing or to overcome the procedural bar on raising claims that could have been raised earlier. Wisconsin Statute 809.62. Nor can Avery show that the Court of Appeals' rejection of his claims is in tension with any United States Supreme Court or published Wisconsin cases. In short, despite what he appears to believe, the fact that Avery's case was the subject of a television show, this isn't gonna go someplace good, does not absolve him from following the well-established rules of Wisconsin procedure. It does not entitle him to a hearing on insufficiently pled claims based only on raw speculation and misrepresentations of the facts, and it does not entitle him to this court's review of a perfectly sound decision by the Court of Appeals. This case does not meet any of this court's criteria for review, and there are no compelling reasons for this court to hear it. This court should deny Avery's petition. You feel the anger percolating right there? We're on page 5 of 12. Argument. This case does not meet any of this court's criteria for review. This court's function is to develop and clarify the law. And now it's citing other case law, which is something that always pisses me off. In order to get your case heard, you have to cite case law where something like this has happened before. Why can't it just be, here are the facts of your case, and why do you need to compare it to something else? I think that is stupid. Accordingly, this court does not grant review unless the case presents an important legal issue on which the lower courts need guidance. This case does not present such an issue. The Section 974.06 motion that Avery filed in June of 2017 was his third motion seeking post-conviction relief. He had a direct appeal in 2011, and he filed a previous Section 974.06 motion in 2013 when he didn't have legal representation. The Circuit Court denied Avery's 2017 motion and his many supplements to it without a hearing because he failed to show a sufficient reason for raising the claims previously, and the record conclusively demonstrated that Avery could not show he would be entitled to relief on any of his claims. Avery misrepresented the conclusions his experts reached and otherwise relied only on wild speculation and conclusory allegations. Kathleen Zellner does not do that. She relies on experts, science, facts. Look at the recreations that she does. Look at the extent that she goes to. They won't give her the RAV4 to look at, so she buys one and does her own testing. Look at how it's in Making a Murderer Part 2, whatever you want to call it, Season 2, Part 2, whatever, where she herself is firing into the garage because a bullet with a red substance on it, yeah, that went through the red particle board garage. So she's shooting the gun herself. A recreation of Bobby Dassey following Teresa Halbach at Cuss Road, and Bobby Dassey and Scott Taddock striking her and all. And then the experts that she has. These are not just Wisconsin's experts like Big Hair Sherry Culhane, who likes to taint evidence and find her in his house or garage. These are real experts. All right, sorry. Now I have to find where I was. The Court of Appeals agreed, holding that Avery had not provided a sufficient reason why most of his claims could not be raised previously. Why couldn't they be raised previously? Because Stephen didn't have Kathleen Zellner, and the evidence wasn't found, or witnesses didn't come forward. That's why. And for those which he did provide a sufficient reason, he had not provided sufficient material facts in his motion that were supported by the record that could establish ineffective assistance of counsel, newly discovered evidence, a Brady violation, or a constitutional due process claim. Now we're on to page 6. Accordingly, there is no law development to be done here. This court has made it abundantly clear what a defendant must show in a Section 974.06 motion to overcome the procedural bar and to entitle the defendant to a hearing. The defendant's motion must provide, quote, sufficient material and non-conclusory facts, unquote. Example, who, what, where, when, why, and how, that, if true, would entitle him to the relief he seeks, unquote. The defendant cannot just make broad allegations and hope to flesh them out at an evidentiary hearing, as Avery did here. Let me try and mark where I was before I go on the rant. Again, he doesn't make broad allegations. Kathleen Zellner doesn't make broad allegations. She only goes where facts and science take her. No broad allegations. Rather, the motion must provide facts to demonstrate how the defendant would prove each element of such claims at the hearing, or the court is not required to hold one. This court has also held quite clearly that the circuit court does not need to hold a hearing if the defendant's motion makes conclusory allegations or if the record conclusively demonstrates that the defendant is due no relief. In other words, contrary to what Avery claims, it is well established that the circuit court does not have to grant a hearing on allegations pled in the motion that the record demonstrates are not true. How do you prove it's not true? How can you prove, let me try and mark where I was. How do you prove it's not true without an evidentiary hearing? When Kathleen has this expert who is the one that is able to identify bones that have been through a forest fire, if you don't have an evidentiary hearing and hear what they have to say, how do you know those aren't true? It's not a wild allegation. And as the Court of Appeals properly recognized, the claims Avery made in his motions were misleading. Nope. Contradicted by the record. Nope. Speculative. Nope. And did not contain sufficient material facts that would establish what he claimed. Evidentiary hearing is what will prove the facts. A filing, you're giving a synopsis of something. You need now the evidentiary hearing to expand on this evidence. And if you care about justice, if you care about what happened to Teresa Halbach, why wouldn't you want to see these facts, these science, hear from these witnesses? Witnesses that came forward back when this case happened and Manitowoc covered up. Shut them down. Avery's new experts all reached conclusions that were consistent with Avery's guilt, and in his motion, Avery simply falsely represented what they said. What? Meaning it would be impossible for him to establish at a hearing that trial or post-conviction counsel were ineffective for failing to conduct these tests, nor could he meet his burden to prevail on a newly discovered evidence claim. Let me read that first sentence again of this paragraph. Avery's new experts all reached conclusions that were consistent with Avery's guilt. What? What? Talk about misrepresenting facts. Virtually all of the contents on the Veli CD were indisputably turned over to the defense, along with Agent Fossbender's investigative summary telling Avery what the state found on the Dassey computer, meaning Avery did not plead sufficient facts showing how he could prove a Brady violation even if a hearing took place. And there is no due process right to post-conviction DNA testing. So Avery did not even plead a cognizable claim about the bone fragments, but even so, Avery did not provide any facts that, if true, would show that if the bones from the Manitowoc gravel pit were human and the victims, he could not be the killer and the person who put them there. He did not plead sufficient facts to explain why the bone fragments could be actually or even potentially exculpatory. Accordingly, he failed to plead facts to show how or why this evidence was at all material. Holy Smurf, this blows my mind. Completely blows my mind. WSC, we already know there was a whole kind of smoke show going on there. And this is also going to ineffective assistance of counsel, that for Kratz to just say to Strang and Buting there's nothing of interest on the Brendan Dassey computer. And they went, okay, and didn't look into it. What did Christopher just send me? Uh-oh. Okay. So Kathleen has posted, Kathleen has tweeted a rebuttal to the state's response posted on our website, KathleenTZellner.com. So when we're done reading this, I will then go to her website and read that. I was also planning on reading the tweets she had posted yesterday. So we'll get into all of that when we're done with this. So first thing in this paragraph, and sorry, I'm getting so many freaking emails and stuff right now too, because I'm planning not one, not two, but 3 events in Chicago in the next 3 weeks, and it's just been anarchy in getting this stuff organized. So WSC, that's also on there where you find out everything that Bobby Dassey had on there on his computer. Well, it's the Dassey Yonda family computer that was in Bobby's room when he is looking up all that disgusting stuff on women and children being raped and murdered on this CD that, Strang and Buting didn't seek out. Ineffective assistance of counsel. And there is no due process right to post-conviction DNA testing. The Smurf, there's not. And with that being said, Kathleen had a deal with the state for her to investigate those bones. And at that time, she didn't even know that they had given the bones to the Halbach family in 2011. So to say that Stephen in 2013, when he didn't have a lawyer, didn't bring up these things, then he should have brought that up then. Didn't know that 2 years prior to that, you gave the bones to the Halbach family, the very bones you claim are not Teresa Halbach. Because Stephen murdered her in the library with the candlestick and never left the library. So these bones that are at the gravel pit, don't look at these bones. We don't even know if they're human. But then you give them to the Halbach family. You don't give them to the Halbach family when she's when they're having a service for Teresa at the time, because Teresa went missing in October of 2005. It's 2011 when you give the bones to the Halbach family. What, where, why? And as we already saw in the other court's response, because the Halbach family wants closure. Again, closure for what? The state's claiming those bones aren't Teresa Halbach. So why are those bones going to the Halbach family? And Innocence Project would beg to differ on DNA. Innocence Project won't take a case unless there's DNA involved. And if you're not going to hold on to facts in a case, evidence in a case, to that, you're just trying to cover Smurf up. point blank in the period. And you're not about truth and justice, and you really don't care what happened to Teresa Halbach, if you're not going to continue to make sure the right person has been prosecuted for this. Is there another Gregory Allen who's out there assaulting women, murdering women, because you just lock up somebody you don't like? Next paragraph. The Court of Appeals did not require Avery to prove his claims in his motion. It required him to state facts that would lead to the conclusions he reached in his motion if he proved those facts at a hearing. That is precisely the proper pleading standard for a Section 974.06 motion. It has also long been settled that this standard also includes providing material facts to establish a sufficient reason why the claims now raised were not raised in a previous motion or on direct appeal. Escalona Naranjo, blah, blah, blah. They're just citing a case. In mere pro se means you don't have a lawyer, you're doing it yourself. And mere pro se status or indigency means you're poor, which was the only reason Avery provided for not raising his claims in 2013, is not a sufficient reason. I gotta. What? Are you? I don't understand how anybody could listen to this and think this is coming from anybody reputable. So being poor and not having a lawyer is no excuse for not having experts or bones that it turns out that you gave to the Halbach family years ago. So he should have brought that up in 2013. Now we're going on to page 8 of 12. Finally, it is beyond argument that statutory claims, such as Avery's argument that the state violated Section 968.205, which it did not do in any event, of course that's what they would say, cannot be raised in a Section 974.06 motion. The Supreme Court has also made it crystal clear that Arizona versus Youngblood does not apply to destruction of evidence, you destroyed evidence, post-conviction, nor recognize a due process right to post-conviction DNA testing, meaning Avery did not raise any cognizable constitutional claim regarding the state's releasing some of the bone fragments to the Halbach family after Avery's appeal concluded in 2011. So then why, when Kathleen Zellner takes the case in 2016, do they tell her they'll give her the bones? Why did they mislead her then if they knew they gave the bones away years previously? I'm not doing that math. What is that math? 6 years? 5 years? I don't do numbers. I don't do math. They told Kathleen she could have the bones. In short, Avery's motion did not include sufficient material facts that would entitle him to a hearing because he did not provide sufficient facts that, and now this is italicized, would entitle him to the relief he seeks. In other words, his motion was insufficient because he did not allege sufficient facts that were supported by the record to show that he could establish any constitutional violations at a hearing. There is new freaking evidence, and evidence that the state covered up. So the record shows that the Court of Appeals did not hold Avery to a higher pleading standard as he claims. It required of him the exact same thing that is required of every criminal defendant who files a Section 974.06 motion. Sufficient, non-conclusory facts, actual facts, not guesswork, speculation, or fiction. Fiction like Kratz's press conference, where he talked about his deviant thoughts. Fiction like you convict Stephen one way and Brendan another for the same alleged crime. That's what I call fiction. Avery simply did not meet his pleading burden, nor did the Court of Appeals improperly fail to consider the cumulative effect of Avery's claims. The Court of Appeals, quote, found each of these arguments to be without substance. Adding them together adds nothing. Math. 0 plus 0 equals 0. Unquote. How many times did they search Stephen's trailer before the key was miraculously found by who? Lincoln Colborn. It was more than 0. These pleading standards and what constitutes sufficient material and non-conclusory facts to entitle the defendant to a hearing have been fully articulated for decades and in cases too numerous to count. There is no need for the court to rehash them. This case does not present any novel, unsettled, or important legal issue, and the Court of Appeals' opinion applying the pleading standard is exactly in line with the decisions of this court and the Supreme Court of the United States. Review here would be simply another walk down the extremely well-trodden path of the pleading standard for Section 974.06 motions. There is no need for further clarification of the pleading standard. Courts across the state easily and properly apply it every day. Yeah, so many people are wrongfully convicted in so many courts. This court's scarce resources should not be spent reviewing the Court of Appeals' simple and correct application of a standard that has already been exhaustively explained in existing, because I'm literally thinking in my head at that time that all this whole response is just the state licking the court's balls. That's why I said licking, because that's what I was thinking in my head. Sorry. That has been exhaustively explained in existing case law. Conclusion. This court should deny Avery's petition for review, dated this 8th day of September 2021. Respectfully submitted, Joshua Call and Lisa Comfer. Let me go to Kathleen's website. Tzo.com. Rebuttal. I don't know, did Christopher already post the link for where you could read this? Is this the right one? Rebuttal to state's response opposing petition to review. Is that the right one? let me click on the Stephen page too to make sure. That's got to be the one, right? Thank you, Bryce. Okay. Here's that link in case he didn't, since I wasn't looking over there. This is 6 pages. Right? This is the right one, right? So this response is 2 columns. So the column on the left is State's response, and then the column on the right is Avery's reply. I got you, babe. Okay. State's footnote 1. Bobby's whereabouts. So the state said, the state's response in footnote 1 reiterates what the Court of Appeals stated about Avery misrepresenting facts. The COA, so that's the Court of Appeals, and I'll just be reading it as COA from here on out. The COA statement, in its opinion, specifically concerned proof of whether Bobby was home alone on October 31, 2005 on his computer. The COA believed there was no proof that Bobby was home alone that day. Proof. Facts. Can be proven. He was home that day. Computer was used. Avery's reply. See Avery's petition. Quote, it is evident that the Court of Appeals was either unfamiliar with the record or disregarded it entirely. It stated that, quote, it was skeptical, unquote, that the Valley report impeaches Bobby's testimony about sleeping and accused current post-conviction counsel of misstating that Bobby was home alone on October 31 during the time the computer searches were conducted. However, the Court of Appeals did not consider the fact that Bobby himself testified that he was the only person home from 6:30 a.m. until 2:30 p.m. that day, the relevant time period of the searches, unquote. Bobby's testimony was that he was asleep from 6:30 a.m. to 2:30 p.m. is clearly impeached. The COA failure to be familiar with Bobby's trial testimony caused it to miss this important impeachment evidence. Next section, the bullets. State says, the state erroneously claims that Avery is contending that the state witnesses testified that the 2 bullets recovered from Avery's garage were actually the 2 bullets used in the fatal shots. The state miscites Avery's petition at page 18. Page 18 of Avery's petition discusses COA's improper reliance on a Southern District of New York case for assessing Brady. And then Kathleen says, the state mischaracterizes Mr. Avery's argument. He has never claimed that state witnesses testified that the 2 bullets in Avery's garage were used in the fatal shots. Rather, Avery's argument is that the COA statement is incorrect, that the state did not argue that the specific bullet, FL, entered Halbach's skull or killed her. The state ignores Dr. Eisenberg's testimony. The state does not acknowledge that the forensic shell casings were not linked to FL or FK, or that Dr. Eisenberg testified that there was no evidence of other gunshot wounds to the bones from other parts of Halbach's body. Dr. Jensen's testimony is that Ms. Halbach's DNA found on the bullet was the result of the bullet passing through Ms. Halbach's brain. The exact testimony from the state's expert, Dr. Jensen, in the record, which is this. Holy crikey, how do I make that get bigger? Okay. So, because then it shows screenshots of the court record for the testimony. Question. Sure, I would like you to simply tell the ladies and gentlemen of the jury what information you have here that allows you to conclude that either of these gunshot wounds occurred while the victim was alive, that is, bullet struck bone while that person was alive? Answer: I don't specifically think that there's any one piece of information that would say that the person was alive with a beating heart or an intact brain. There's material, and I was given information that there was a spent bullet recovered at the scene that contained the blood specimens of the decedent. And that would be indicative to me that the bullet had passed through the brain at a time, whether it was liquefied blood or that it wasn't going through specifically bone fragments. And I would think that that would be the predominant, that would be information that I think would be helpful in making that type of opinion. Question: all right, we have certainly had testimony that Teresa Halbach's DNA was found on a bullet fragment. Answer: right. And now I got to blow up this next page because totally can't read it. Question: I at least recall no testimony that Teresa Halbach's blood was found on a bullet fragment, but the jury will decide in the end that. And in a sense, it doesn't matter. Is there any way to distinguish the bullet hole you saw? Either one from a gunshot that was fired into the head of an intact corpse, from a gunshot that was fired into the head of a living person? Answer: I don't think I could make a definitive determination based on whether the individual was in a perimortem time frame or whether the individual was skeletonized. It would be my opinion that the wounds showed an intact, robust bone that is consistent with what I would say non-skeletonized material, meaning that these look typically like an entrance wound through a bone of a person who is not a skeleton. And the reason I described that I could make that clarity is that in a skeletonized bone, where you have got dried bone material as the bullet passes through, oh boy, I would suspect that there would be a different kind of fracturing and that it wouldn't get the same type of gunshot wound, particularly of death, if the gunshot wounds occurred after death. Answer: on the cause of death, yeah, I would say so. Question: and then likewise, once we don't have a cause of death, it's similarly difficult to assign a manner of death? Answer: well, medical examiners and forensic pathologists don't make determinations on manner of death in a vacuum. We utilized, as I mentioned, evidence from the scene. And if we can go, okay, and if we can go to the scene personally, we use that information. Or if we can't, then we use photographs and other people's reports to use that information. We use laboratory data. We use evidence that's recovered. And we put that together and we render our opinion as to what the manner of death is. We don't do it in a vacuum with a single piece of information in isolation from all others. Question: of course not, of course not. And in a cause of death, for example, you cited to these jurors your understanding that a bullet or bullet fragment was found with what you thought was blood of the victim on it, and that initially factored into your opinion on cause of death? And now I have to scroll out a little because we're going back into her state side, her side. So next section says state's footnote, IAC claim. The state claims that Avery is miscasting his newly discovered evidence claims as ineffective assistance of counsel claims in his petition. And Kathleen says it is the COA that casted Mr. Avery's newly discovered evidence claims as ineffective assistance of counsel claims, not Mr. Avery. State's response, COA errors. The state argues that the Wisconsin Supreme Court is not an error-correcting court. Kathleen's response. Mr. Avery asserted in his petition that, quote, the court's blatant misstatement of the facts undermines the integrity of its opinion, unquote. The state misconstrues Mr. Avery's petition. He is not asking that the Wisconsin Supreme Court edit the COA factual errors. Rather, Mr. Avery claims that the COA's unreasonable application of facts, including its significant factual errors in determining the facts, supports his argument that the COA's decision opposes United States Supreme Court and Wisconsin Supreme Court precedents. Next section. State's response, compelling legal issue regarding Brady. The state claims there is no compelling legal issue for the Wisconsin Supreme Court to address. Kathleen says, the misapplication of the Strickland standard requiring Mr. Avery to prove his pleading would establish an acquittal is contrary to United States Supreme Court and Wisconsin Supreme Court cases. Further, the COA's analysis on the WSC, Mr. Avery's Brady claim, is unprecedented and relies exclusively upon a Southern District of New York opinion that is inapposite, I don't know that word, and so I'm not sure how to pronounce it, and has been criticized and not followed even by other district courts in New York. More importantly, the COA's opinion directly contradicts the Wisconsin Supreme Court in State versus WSC. Next section, state's response, Avery's experts. The state claims that, quote, Avery's new experts all reached conclusions that were consistent with his guilt, unquote. What a crock. Kathleen says, Avery's experts refuted each claim made by the state in his trial by demonstrating through experiments and their own expertise some of the following. 1. That the blood in the RAV4 did not come from an actively bleeding finger, as the state claimed, and it would have been in many more places in the car. Door handle, gear shift, key, steering wheel, and hood latch. And that the blood above the ignition was placed there using an applicator, and the blood flakes on the carpet had been placed there after they were dry. 2. That the DNA on the hood latch swab was 90 times greater than the DNA that would be deposited by opening the hood latch one time. 3. That Avery's DNA on the ignition key found in Avery's trailer 10 times more what Avery deposited on an identical ignition key on an experiment. Ignition key or valet key? 4. No human body was ever burned in Avery's burn pit, and the bones in his burn pit had been placed there. 5. That no plastic was ever burned in his burn barrel, which had foliage growing in it. 6. That it was impossible to duplicate the RAV4 key being discovered in its location by the testimony given by Sergeant Colborne about shaking the bookcase. 7. That the bullet FL did not have any evidence of skull fragments demonstrating that it had ever entered the skull of Ms. Halbach. The state never explains how these findings were consistent with Mr. Avery's guilt. Next section. State's response, CD. The state advocates for a new Brady standard when it contended that, quote, virtually, she has italicized and underlined, virtually all of the contents of the WSC were indisputably turned over to the defense, ... unquote. Kathleen says, there has never been any court that has endorsed a, quote, virtually all of the contents, unquote, standard. The state is conceding that the contents of the WSC were not identical to the 7 DVDs because the state creates a new standard for a Brady claim. It does not address the significant evidentiary differences between the DVDs and the CD, and it does not deal with the state's misrepresentations to trial defense counsel that the computer belonged to Brendan and had nothing of evidentiary value. Significantly, the COA admitted with the new witness who saw Bobby Dassey pushed Ms. Halbach's vehicle after her disappearance that the CD might establish his motive as a third-party Denny suspect in a new 974.06 filing. State's response on the bones. The state defers to District Attorney's Office for 3rd Judicial District versus Osborne for its proposition that there is no right to DNA testing of bones. Oh my God, that just infuriates me. Kathleen's response. Osborne specifically refers to a federal due process right to DNA testing. Osborne defers to the state's DNA statutes. Osborne merely states that there is no right to federal DNA testing, allowing the states to impose their own DNA statutes. The state's response is a complete misinterpretation of Osborne. State's response on sufficient reason. The state claims that, quote, the only reason Avery provided for not raising his claims in 2013, unquote, is Avery's, quote, mere pro se status or indigency, unquote. Kathleen says, this is simply not true, as evidenced by the COA opinion, which analyzed Mr. Avery's many reasons for his inability to raise his claims in his 2013 petition and accepted one, that, quote, it would have been impossible for him to have undertaken the extensive investigations later carried out by current post-conviction counsel, which resulted in new theories as to how he was framed and additional factual support for previous theories, unquote. Mr. Avery raised several sufficient reasons for not raising his claims before in his 974.06 motion. And that's the end of that one. So let me go back to Stephen Avery projects, because on Stephen Avery project, where are you? Why are you going there? No, I don't want groups. Go back. I want pages. Anytime Kathleen Zellner tweets, I get a notification, and then I take a screenshot and I post it on Stephen Avery project. And something that she does all the time is she tweets something and then she takes it down. Like maybe there was a typo or something in it. And then she puts out another one. And then she'll tweet out another one that's almost the same exact language. But she takes tweets down all the time. So I posted them before they were taken down. So let's just read what she put here. First one she posted yesterday said, state response creates a new Brady standard if the evidence withheld is virtually the same as that disclosed, no problem. That television show is of more concern than the COA factual errors on bones in Avery's burn barrel, magic DNA bullet, or Bobby Home Alone 1031 testimony. And then she's got a screenshot that says, newly discovered evidence claim. Virtually all of the contents of the Veli CD were indisputably turned over to the defense, along with Agent Fassbender's investigative summary telling Avery what the state found on the Dassey computer. Meaning Avery did not plead sufficient facts showing how he could prove a Brady violation even if a hearing took place. So that was her first tweet. Get off. And then she pulled that one down, and then this one had been up. Kathleen said, state's response claims there is no Brady violation if the state decides the evidence suppressed from the defense is virtually the same as what it turned over, ... said no court ever. And then it has the same screenshot. So that was number 2. Get off. Then the next day she tweeted, if we had wanted to reread the COA decision again, we could. The state's regurgitation response addresses none of the errors raised in the petition. Stephen Avery waits for justice again. And then get off. And then she took that one down and instead put, if we had wanted to reread the same error-filled COA decision again, we could have. The state's regurgitation response addresses none of the errors. It just repeats them. Justice delayed again for Stephen Avery. Was that the last one? Okay, yeah, that was the last one. So there you have it. We have read the state's response to her filing with the Wisconsin Supreme Court. And now Kathleen has tweeted her rebuttal to that laughable response. You don't have to be a lawyer to see what a bunch of crap that filing was. But it doesn't mean that the court won't agree with the state. And just because if the Wisconsin Supreme Court denies this, it doesn't mean that Kathleen is wrong or the state is right. It's just that, first of all, the Supreme Court, whether or not it's a state or the Supreme Court, the U.S. Supreme Court, they take such a small percentage of the cases that are sent their way, which I find really infuriating because that's your job. But they can say, nope, we're not gonna, no, not even gonna think about it. We know the evidence is there. And the more you try to stop to show evidence, you're trying to show evidence. Why do you not want to hear evidence that proves that you have the wrong people incarcerated and that somebody could still be out there hurting people? I don't understand why it is so hard. But Kathleen says it typically takes 15 years to overturn a wrongful conviction. 15 years. From when she takes a case, not just in general. So all the years Stephen and Brendan have been in prison prior to 2016 doesn't count, because she's only been on the case since 2016. And there absolutely was ineffective assistance of counsel. And I am not talking crap about Strang and Buting when I say that. Mistakes happen. And Strang and Buting did not have the money Kathleen has. And they didn't have all the internet detectives in a Netflix documentary to show them other things. They did not have these resources. So, but it's clear that mistakes were made. The very least, there should be an evidentiary hearing. Stephen's never giving up, though, and Kathleen Zellner's never giving up on him. And she only takes cases when she knows they're innocent. When will Wisconsin Supreme Court respond? We don't know. Do I think the United States Supreme Court will take the case? Probably not. Why do you think they were so smug in their response? Because it just seems to be once a Smurf, always a Smurf, and you double down on that cockiness. I think they're painted into this corner, and they're gonna defend it with everything they got. And everybody helps protect that lie. And who suffers? Stephen lost his mother 2 months ago. The one person, well, there's two people. His cousin Kim Ducat is the only other person who has been in Stephen's corner the entire time. No doubt, no talking crap. Matt's asking, what do I think the ramifications are if Stephen is found not guilty? Um, I guess it would depend on how it's ruled. Because there's the crazy, because if you're able to prove that lawyers or cops or whatever have falsified evidence, that then makes every single case those people have been involved in suspect. So that could be huge consequences and a can of worms that nobody wants to open. That's going to be an ugly mess. And we see what's happened to Stephen in Manitowoc twice. We've had people on Stephen Avery Project, in MAM Gossip, who are from that area, who talk about many other cases that happen there. And how many more are there that we don't even know that this group of co-conspirators were all involved in? Millions in settlement like before? Absolutely. But I don't know how you put a dollar amount on what Stephen has lost. I had always joked with Stephen that they just should change the name of Wisconsin to Averyland. He should own everything. Because you already took from him the first time you took him away. He lost his wife. He lost his children. I mean, he lost so much. Then he's out for 2 years. Gets a girlfriend. I know Jody is a piece of smurf, but at that time, he loved her. He's going to come into some money that's going to change not just his life, but his parents' life. 2 years is not enough time to make up for losing 18 years of your life, to rebuild your life back, to rebuild your relationships with your family. And then you take him again. Loses his girlfriend. And now his mother has died. And when Stephen was taken the first time, he was 22 years old. He has barely been able to be a free man, free adult. You have taken his adulthood from him. He's what, 56 now? I don't know how you figure out a dollar amount for what Stephen has lost. You can't replace his mother. That is the most tragic thing ever. Debbie, no, I have not heard from Stephen. He had called me the week after his mom died, back in July, and I haven't heard from him since. So, So no, I don't have any contact with him currently. But all right. Um we had a raffle. So it was somebody, a longtime supporter of Stevens, who wants to remain anonymous. She wanted to do something. We had been doing that rally at Stevens Prison. And so, and I should have brought the stuff up here, but like I said, I'm twirling so many things right now and trying to organize this stuff in Chicago, that I didn't bring it up here. Um, but it's a Scentsy wax warmer thing. That's so there's a post here on Stephen Avery Project where you can see all the items that are in there. So that person had purchased that and some wax tarts to use that, you know, you plug it in, turn it on, and it puts the nice smell in the air. And so there's that and the wax tarts. And then Christopher, one of the moderators here, has an Etsy store where he makes all kinds of scented things, the wax tarts, the soap, bath bombs, all this stuff. And so Christopher donated some stuff for it. I put in there a Stephen Avery shirt, one of the fans I made for the rally, the masks, stickers. Um, One of the people who came to the rally had some leftover soaps from when she got married that she donated to it. So it's this big old goodie bag of stuff. And so people were able to buy raffle tickets. Hold on, there's my husband saying busy. Yep. Still live, done in a few. Um so I've got all the people that had purchased raffle tickets in this hat, my Dumb and Dumber hats. Years ago, my husband and I dressed up as Dumb and Dumber. I'm sure all my haters will love that. Um, so I'm just gonna draw a name. Everybody's names are in here. I folded them exactly the same. Um, and I'm just gonna draw one name out of here, and that person wins the prize pack. You ready? All of you doing the drum roll in your head? This is the, it's not a golden ticket, it's pink. What name will it be? Agnes. So Agnes is our winner. So we'll have to reach out to Agnes for their address. So I can, you know what? Yeah, Agnes will reach out to you for your address and send out your prize. And I think all of you, I don't know if you're watching this, but send Stephen Avery Project, or you can email me at officialstephenaveryproject@gmail.com. Send me your address and I'll send you a little thank you for participating gift as well. So yay, congratulations to Agnes. Whenever the Supreme Court, Wisconsin Supreme Court rules, I will go live and we'll do just like we did today, where we read it and we discuss it. And if you see it before we do, send it our way and we'll get it posted. And then, don't know when I'm going live next We are going to be doing a live on my Justice with Jax page. We haven't made the event for it yet. But Melissa Kaluzinski, who is another client of Kathleen Zellner's that I advocate for, her birthday is October 4th. So we're going to do a live on Justice with Jax for Melissa's birthday. Christopher always calls it like an online rally thing. I don't know that we're going to do like a whole day of stuff. I think it might just be an hour or so where I'll talk about the case. You can ask me questions about the case. And then I'm visiting Melissa on Monday. And I'm going to talk to her about the live we're going to do for her birthday. And I'm going to see about maybe getting Melissa to call me on her birthday, and then I will put her on speakerphone and y'all could talk to her. We've done that once before in a live that I've done with Melissa, and obviously you can't ask her anything about her case. She can't talk about her case, but you know, it would just be so you could hear her, and you could wish her a happy birthday, and you could ask her some questions about, I mean, what's it like to be in prison, or, you know, things, whatever. But she can't get into the details of her case. So that will be October 4th. Also, October 2nd is Wrongful Conviction Day. And that's a Saturday. But that's one of the events I'm currently organizing that's going to be in Chicago. So I won't be doing like a live thing on the 2nd. But usually on a Wrongful Conviction Day is a thing like people take a picture of their porch light left on, and you know that's symbolizing, you know, hoping and waiting for the wrongfully convicted to go home, and people make signs for the people that they're thinking of that are wrongfully convicted, and you take a picture of it and post it. So we'll come up with something. Oh yeah, Maz, absolutely, send her a birthday card. We'll post over on Justice with Jax her address for people to send Melissa out a birthday card. Great idea, Maz. So that's the next live that I know of, is October 2nd on Justice with Jax on the Melissa Kaluzinski case. For Stephen's case, we go live when something else happens to discuss. Or there's times where I'm like, oh, I don't have anything going on right now. I'll pop on here and people can fire questions at me about the case, and we can just talk about the case in general. So that could happen at some point. But I don't know, I've got the event tomorrow, then an event on the 18th, and then October 2nd. Well, I'm sure I'll have time in the middle of there. So maybe one day, yeah, we'll pop live here again on Stephen Avery Project, and we'll just talk some more about the case. Did I cover everything? Agnes, if you watch this, we need your address, and I'll get your prize pack sent out to you. And I want all the other people to send me their addresses so we can send you a little something too. Thank you. And we still have the Justice with Jax Etsy store where I've got all these stickers. And you'll have to go to the store because I don't even have all the stickers up here. But we made some other ones too recently. So if you're interested in any of those stickers. Maz is also on my personal Facebook page, so she's asking how many monarchs did I save this year, because I plant milkweed and such to try and save the monarch butterflies here, and last year I had hardly any. This year, Maz, I think I had like 10. So still not a good year here for me for monarchs to have only 10. The year before, so 2 years ago, I had so many. And this year, yeah, so I just released one, what was it, 3 days ago? And I believe that'll probably be the last one I have for this year. Most of my milkweed is not healthy, now, that it's yellowed and everything, so it's not good for the monarchs to eat anymore. So, all right. I'm going to go see what my husband wanted. I do post to the UK for the stickers. Yes. All the information, Joe, is in the Etsy store. So, yeah, so it's in there cuz I mean, these stickers too, I'm sticking them in an envelope. So it's not as a big deal to do. So the stickers we do internationally, but this prize pack with how big it is and the stuff's in there, we did it states only because I'm not going to get into that whole mess. I'm trying to figure out how to send that box of stuff internationally. All right, I'm definitely out and going to go see what my husband wanted. Thank you so much for joining me today. But more than that, thank you for supporting Stephen Avery's innocence. We're never going to give up. We stand by Stephen. We know he's innocent. And as usual, investigation continues.